and that must be according to Sunni law. The acceptance of the proposal should be in presence of two Mohammedan witnesses, two Mohammedan witnesses, then Mohammedan witness, one Mohammedan or two female Mohammedan witnesses. But if, but no, nowhere the law requires that for marriage contract, dower must be paid immediately, or dower must be settled there, then or there, at the time of marriage. But this is a concept, this dower or meher. It is a concept in once there is a marriage, the wife is entitled for that or meher. Why? Why? Because the object of dower, what is that? To impose a restriction on the capricious use of diverse power by the husband. First thing. The object of dower is three. That is to impose a, that is capricious act, restriction in the capricious act of the husband to divorce the wife. Then that is second is when a dower is paid, that dower is paid as a dower or property. Dower is maybe money or property. That is paid as a mark of respect to the wife in marriage. Second. First is that is mark of respect to the wife. The dower is paid as a mark of respect to the wife, and the wife is marrying the husband. Second, because I am submitting herself to the husband, that is a mark of respect. This, that is obligation on the husband to pay the dowry is a mark of respect to the wife. This is an obligation. First objective. To impose an obligation on the husband to pay dowry or meher as a mark of respect to the wife. Second, to place a check, to make it, to check, to restrain the husband who uses this whips to divorce the Muslim wife. That is, for that dowry is fixed. Dowry is to be paid. Then, third objective is that once the wife is divorced, then on getting the dower, she will be rehabilitated. So after dissolution of marriage, this dower provides a subsistence to the wife. That is, thereby the wife will maintain herself. So this object of his dower is this. First, it is obligation on the part of the husband to pay dower or meher, which is a mark of respect to the wife. Second, that it restricts or it coerces the husband or it restricts the capricious power of the husband to pronounce talaq or to divorce the Muslim wife. Third is that even after dissolution of the marriage, in case the marriage is dissolved, the dower will just save the wife from this starvation. The wife will be rehabilitated by that dower. So, dower, this dower is the money or property which is the wife is entitled, not paid at the time of marriage. The dower is the money or property which the wife is entitled. What for? To receive from the husband in consideration of marriage. So never misconstrue or never just keep an idea that dowry is a consideration for the marriage. No. Because for Muslim marriage, no dowry is required. That dowry is more the free. Dowry is not a precondition that is not to be paid at the time of entering the contract. That is not fixed. Even it is the law doesn't require, Muslim law doesn't require that dower must be paid immediately, or dower will be a consideration for the marriage. But that has been defined in so that is a sum of money or other property which the wife is entitled to receive from the husband in consideration of marriage. Entitled to receive. So consideration as used in this definition by Mullah is not the same as the consideration defined in the Indian contract. You know how consideration has been defined. So even if no dowry is specified at the time of marriage, marriage is not void. Marriage is valid. And on that account, but the law requires that some dower should be paid. Even thereafter, the dower is to be fixed by the court. Paid to wife, and even if no dowry is fixed, the wife is entitled to same some dower from the husband. This is asked you to know what is dower. Dower means, if a question is put, what is dower? Dower may be treated as a consideration, but it is a money or property which the wife is entitled to receive as consideration for the marriage. But not a consideration after marriage, the wife can also receive that money, entitled for the money. Some dower is due. So this dower originated from Holy Quran. What Prophet in the what Quran dictates says, give a woman their dowry freely, and if they are good enough to remit any of it themselves, then devour it with good digestion and appetite. So this is Amir Ali said, the measure of the Islamic system is similar, said Syed Amir Ali, in all its legal incident to the donatio propter nuptial of the Roman. In the Roman law, even some money is paid for the purpose of in the marriage, but that is a contract for consider. There is, however, this essential difference in Roman there is a rule that is donatio propter nuptials and the measure of the the Mohammedan, that whereas the former is purely voluntary, under Mohammedan, this Roman law, some money is also paid to the wife, that is voluntary on the part of the husband, but in case of Mohammedan law, dowry is compulsory, obligatory. The husband is under obligation to pay it. Fatwa Khaji can say, meher or dowry is so necessary, that is to the marriage that if it were not mentioned at the time of marriage or in the contract, the law will presume it by virtue of the contract itself. Since there is a marriage, the wife is entitled to the dowry. When there is a marriage, dowry is a must. The wife is entitled to the dowry. So, essential condition of the second marriage is dower, but the validity of the marriage does not depend on it. Once there is a marriage, there must be a dowry. So, that is, the husband is obliged under obligation to pay dower as a mark, or dower means any money or property, as a mark of respect to the wife. So here, that is the property or the equivalent of the husband, either by reason of being agreed in the contract of marriage or by virtue of the contract, a special consideration for the marriage. Because this right of enjoyment, one the husband unmarried
Yes, the body of the wife. So that's why he is obliged to pay dower to the wife. Dower has been defined to an effect on the marriage contract, which is imposed upon the husband as a mark of respect for the wife and as a consideration for the carnal use of her. It is the consideration for the carnal use of her body, the husband will enjoy the body of the wife. This is dower. So now, if by now you are aware what is dower. Dower is an obligation. The husband is bound to pay dower. So dower as a civil contract, according to Muslim law, marriage is a civil contract, dower is a necessary result of it. Once there is a marriage, the necessary result is that the husband is obliged to pay dower to the wife. Then, object of dower, I have told you three reasons. First, mark of respect to the wife in marriage. Second, to restrict the husband to use his capricious will to divorce the wife. Third, once the wife is divorced or the marriage is dissolved on getting this down money, the wife is inherited. So, now if this is the thing, because dower is to be fixed at the time of marriage, or after that, or before the marriage, when it is to fixed, you should know it. Settlement dower is usually made before or at the time of marriage. So, it is usually, the dower is settled either before marriage or at the time of marriage. But there is not an essential prerequisite of the contract of marriage. But it is not a prerequisite that dower must be fixed before marriage or after marriage. An agreement for dower of yours is nonetheless binding on the husband because it was made after the solemnization of the marriage. Even after the solemnization of the marriage, this dower is, the husband is liable to pay dower. Even the amount of dower may be increased, that can be increased subsequent to marriage, that can be decreased at any time after it is fixed. So if it's so, then what is the minimum amount of dower? As per the Sunni law, the minimum amount of dower is 10 dirhams. It is 1 dirham is about, this is very nominal amount nowadays, 3 to 4 rupees. But according to Shia law, no minimum amount of dower is there, but maximum is 500 dirhams. So here, determination of the amount of dower is ordinarily fixed by oral contract. By oral contract, the amount of dower is fixed, and this is why.
The Shia law doesn't fix maximum amount is 500 dirhams. So usually, how dower is fixed, that entirely depends on the circumstances of the husband and the wife. That is fixed. That dower is fixed. It should not be arbitrary excessive. That is, the husband, the arbitrary exercise the power of divorce vested in. The position of the paternal family, how dower is fixed, position of the husband, financial position of the husband, the beauty of the wife, educational qualification of the wife, then wealth of her husband, condition of society surrounding her, and the desire of self-glorification and vanity on the parties, on the part of the parties. Those circumstances regulate that is influence the fixing of dower. That is, the amount of dower is determined first in the following way. In the case of valid marriage, the wife gets a full specified. In a valid marriage, the wife gets a full specified proper dower, as the case may be. In the case of a valid marriage dissolved before consummation by divorce, suppose the marriage is not consumed, thereafter the marriage was dissolved or by apostasy. Apostasy, suppose the husband accepted another religion. The dower payable is one half of the specified dower. In the case of marriage was irregular, that is facet marriage, and has been consummated, she gets specified or proper dower whichever is less, and where no dower is specified, she gets only proper dower. In case of irregular marriage which has not been consummated, once irregular marriage has been consummated, facet marriage, the wife is also entitled to get proper dower. But if it has not been consummated, that the marriage is dissolved, then this is then the wife is not entitled for any dower. Then dower may be categorized, classified. That is what in two. First is specified dower and the proper dower or customary dower. Dower may be classified into two. First one is specified dower and the other is proper dower. What is specific? Then specified dower is prompt dower and deferred dower. Prompt dower, what is prompt dower and deferred dower? So, or prompt dower, that is the dower payable on demand. Deferred dower means payable in dissolution of marriage either by death or divorce. Now let us see what is specified dower. Specified means the amount has been specified. It has been determined. If the amount of dower is settled in the marriage contract, it is called the specified. If at the time of marriage contract or before the marriage contract, the amount has been specified or determined, we say that is a specified dower. Dower may be settled by whom? By the parties to the marriage, either before the marriage or at the time of marriage, or even after marriage. If the marriage of minor is solemnized, performed, or a lunatic boy's marriage is performed by the guardian, guardian can also settle the dower. Dower once settled by the guardian, that cannot be reduced by the boy after attaining majority. That is, majority here means puberty, not this according to majority as per the Indian Majority Act, or after becoming 7. The husband may settle any amount he likes by dower upon his wife, though it may leave nothing to his heirs after payment of the amount. If the husband has settled the dower, even whatever property left, first dower will be paid. That is to the wife. This is called specified dower. Now, what is prompt dower? Prompt dower is that is, it is payable immediately on marriage taking place. So, prompt dower is that it is payable immediately on taking of the marriage. Should have very moment the marriage making the taking place. When marriage takes place, the dower is to pay, and it must be paid on demand unless delay is stipulated for or agreed. That must be paid on demand unless delay is agreed or there is a condition. It does not become deferred after consummation of marriage. Once the prompt dower is there, even marriage is consumed, thereafter it does not become a deferred dower. And a wife has absolute right to sue for recovery of prompt dower even after consumption. Once a prompt dower is there, that is agreed, even after the consumption of marriage, the wife can recover that amount of dower as it is a prompt dower. It is only the payment of the prompt dower, the husband is entitled to enforce the conjugal rights. Once a prompt dower is there, unless so long the dower has not been paid, the wife is not under this obligation for the conjugal rights, unless the marriage is already consummated. So if the consummated, that is different thing. As it is payable on demand, limitation begins to run on demand refusal. So, dowry is to be treated as a debt due by the wife from the husband. Once there is a prompt dower and demand is made, on that day if the husband has not paid, the wife can sue the husband for realization of the dowry amount as a debt. So that is here the this is as it is payable demand, limitation begins to run on demand and when the husband refuses to pay it. Now the second is this is called prompt dower. You should know what is prompt dower. Prompt dower means which is that is payable immediately on marriage taking place. Immediately on marriage taking place. It must be paid on demand and unless delay is stipulated or it must be paid then and there on demand unless delay is agreed or stipulated. It does not become deferred after consummation of marriage. Even if the marriage is consumed without receiving the prompt dower, it will not be treated as a deferred dower. And wife has absolute right to sue for recovery of the prompt dower. It is only when there is a prompt dower, it is only on the payment of the prompt dower the wife will submit her to the husband, unless there is a consumption. As it is payable on demand, the period of limitation will run from the date when the husband refused to pay that dower for realization. Now the deferred dower. What is deferred dower? So if deferred dower is that dower which is not paid, which is not payable immediately at the time of marriage, but it is payable on dissolution of marriage or by death or divorce of the husband. Deferred dower is that dower which is payable to the wife on the death of the husband or by the divorce to her by the husband. The wife is not entitled to demand payment of deferred dower so long the wife has not been obtained, has not been divorced by the husband or the husband is not dead. The wife is not entitled to demand for the dower. Though what is after the death of the husband, the widow is entitled for the dower as a debt due to her from the estate of the husband. The widow may relinquish her dower at the time of her husband's funeral by the recital of the formula, but the relinquish must be voluntary. Even if a widow, she may relinquish her dower, this deferred dower, by making a voluntary formula, by voluntarily reciting something. The interest of the wife on the deferred dower is vested one and not contingent one. Like a vested interest, even after her death, that will be succeeded by her successor. So this is this deferred dower. Now you are aware what is specified dower? The specified dower may be divided into two categories. One is prompt dower, which is to be paid then and there, and then deferred, which is payable only on death or divorce. The wife is not entitled to demand payment of deferred dower. The widow may relinquish that dower. So this is deferred dower. Now what is proper dower? Proper dower is that dower when the amount of dower is not fixed in the marriage. When the amount of dower is not fixed at the time of marriage contract, or even the marriage has been contracted on the condition that she should not claim any dower, or the marriage is performed, the marriage was contracted with condition that she will not claim in dower. So that is called proper dower. Even by saying the contracting the wife will not get the dower right will not go. So what is that? When the amount of dower is not fixed in the marriage contract, or even if the marriage has been contracted on the condition that she should not claim any dower, the wife is entitled to proper dower. There is a misconception in your mind that when the wife has agreed not to accept dower, how? She will entitle. No, this Muslim law says even the wife has not has contracted at the time of marriage that she will not claim any marriage. So still a right of dower is there, and that will be treated as a proper dower, customary dower. Proper dower is otherwise also known as customary dower. How that proper dower is to be fixed? So far as specified dower is concerned, that is fixed according to will of the parties. But in case of proper dower or customary dower, that is to be fixed considering the following: the first, the personal qualification of wife, her age, beauty, fortune, understanding, and virtue. Suppose educated Muslim woman, a highly qualified Muslim woman, suppose a doctor or a service holder, then for the proper dower, the personal qualification of the wife, her age, what is young age, beauty, fortune, understanding, and virtue, all are to taken into consideration fixing the proper dower. Social position of her father's family. Second, the father's family, the Muslim woman's father's family's social position will also be taken into consideration for determination of proper dower. Dower given to her, this female, that is this relatives, that is also to be her mother or sister, that is also to be taken. Economic condition of her husband, circumstances of time, these are to be considered for fixation of the proper dower. Wife rights and remedies for non-payment of dower. Now a question will come: what the woman will do? The wife, what right the wife has to enforce for non-payment of dower? The wife's right and remedies or non-payment dower is refusal to cohabit. If dower is not paid, the wife has a right to refuse to cohabit, right to claim the same as a debt, right to retain. This is husband property. Retain means possess. This is husband property. This is these are the rights of the what? The wife for and the remedies of the wife for the dower. Sometimes you get a question, write short note on kharchai pandan. Kharchai pandan. It is different from dower. What is kharchai pandan? Most of the time we get a question. In the scissors as well as judicial service examination, write short note on kharchai pandan. Kharchai pandan is beetle box expense. Means a beetle box expense. Wife which is it is different from dower. Although it partakes of the nature of dower, though it is like dower, but no, it is something different from dower. It literally means the beetle box expense. Kharchai pandan means beetle box expense. It is also known as allowance for mewa khori. It is customary among Mohammedan families of rank of northern India. In the Mohammedan families of northern India, to fix which varies according to the means and status of the parties. Consider the means and status of the parties. That to fix that is give a personal allowance for female either before marriage or after marriage as kharchai pandan. So India to fix a personal allowance, it is monthly allowance, personal allowance, a personal allowance for female after or before marriage. Even after marriage that can be contracted. It is a personal allowance of the wife which she is entitled to recover but cannot pass to her heirs. Only difference is that Once dower is not paid, then dower is to be succeeded by the heirs. But Kharchai Pandan cannot be succeeded by the heirs, but the wife is entitled only to get that allowance. Personally, the Kharchai Pandan is payable to wife so long as she lives with her husband. The second condition is that so long the wife lives with her husband, she is entitled for Kharchai Pandan. That is called the pin money. However, is spent during coverture with the advice and at the instance of the other. Thus, where a marriage was contracted between the minors through their guardian and the father of the minor husband agreeing to pay certain specified in consideration of the marriage to meet the expense of the wife's charge for some of the properties for the payment thereof. That is to be treated as Kharchai Pandan. The wife, though not a party to the agreement, even this guardian can enter a agreement that is beneficiary. The wife is entitled for the benefit of that agreement. It was further observed that the husband has hardly any control over the wife's application of the allowance. Whatever money is paid as Kharchai Pandan, the husband has no control over that money. That is Kharchai Pandan. So this is, as I would discuss, specified dower, then proper dower, prompt and deferred dower. Deferred dower means which is to paid later. The dower amount may be increased subsequent to marriage. It may be decreased also. So, guaranteed dower is that dower when somebody has stood as a guarantor for the dower, that is called guaranteed dower. You say guaranteed dower. The payment of dower may be guaranteed by a person. So guarantee may be accepted by the woman. Guarantee may be accepted by the woman if she be adult or by her lawful guardian. Such amount may be recovered from the guarantor. This is among Sunni. The father of the minor husband does not become, but once become personally liable for the dower by the mere fact of the marriage having been arranged by him, unless he himself has guaranteed. If the father had guaranteed as a guardian, then that dower amount may be recovered from him as a guarantor. What is disputed dower? Suppose a dispute comes regarding dower. Where dispute arises between the spouse and the amount of the dower, the proper dower is to be fixed. The proper dower is to be fixed according to what I told you earlier, that considering the social status of the party, the beauty, qualification, intelligence, virtue of the wife, the financial condition of the husband, all sorts things are to be taken into consideration. Wives have two rights when dower is not paid. In the event of non-payment of prompt dower, only in case of non-payment of prompt dower, the wife has a right to refuse to live with the husband and to admit him to sexual intercourse. Only in case of prompt dower. So a Mohammedan cannot, according to Mohammedan law, maintain a suit against his wife for restitution of conjugal life when prompt dower, even after such consumption with consent as is provided by cooptation for 5 years, where the wife dower is prompt and has not been paid. Even wife dower, prompt dower, and the Mohammedan has not paid the prompt dower, see, he cannot file a suit for restitution of conjugal life. This is so far as prompt dower is concerned. This wife can retain the husband's property so long the dower is not paid. If that property is in possession of the wife, then you understood what is Kharchai Pandan. So you should know what is the difference of dower. That is difference between Sunni and Shia law relating to dower. In Sunni law, the minimum dower is 10 dirhams, maximum is no limit. But in Shia law, there is no minimum limit, maximum is, that is 500 dirhams. So, so far as agreement of no dower, an agreement that no dower shall due is void. If there is under Sunni law, such agreement by sane and adult wife is valid. Then consumption of marriage, a marriage dissolved by death and dower has not been specified. Proper dower would be due whether the marriage was consummated or not. If either party dies before consummation of marriage, dowry is not payable as per this law. Not specification the whole may be awarded as a prompt if it has not been regulated by the custom usage of the families, or in the absence of any proof of custom, party is regarded as prompt and part of deferred dowry. The whole is presumed to be prompt. So far as you know what is dower, most of the time you get a question, what is dower? What are the difference between different kinds of dower when dower is liable? By this, we concluded the system of dower under Mohammedan. Thank you.